and compliance update. If you are joining us for the first time, just want to run through a few administration issues. If you have any questions, if you want to put those on the system, and I'll pick those up at the very end. If you're a solicitor, then it's A2 for competency purposes. It is being recorded today, so that will be available to you. The slides are on the system, so if you want to pick those up now, you can do, or you can pick them up later on. Excuse me. If you're not connected with me on LinkedIn yet and are following all my blogs and posts and things like that, then please do send me a request to connect and I'll be glad to accept. We've put links at the bottom of each slide, so if you want further information on the various slides, then you can go straight to those. That is once we've actually finished the recording, that the links aren't live until you go to the slides. And of course, don't forget to click Save a Seat to register for future webinars. Okay, and talking about webinars, we've got a data protection update coming on the 18th of September. So we'll be discussing all sorts of different things around data protection, including the new act that has come in and how that's going to impact on law firms in different ways. So please do come to that one. If you missed the Ask Me Anything About AI webinar that we did on LinkedIn, we did it as a LinkedIn live event, then you can actually click on the link there and you can go and view that. Again, we weren't being technical on this particular webinar. We were trying to give people an insight into what AI is, what it's all about, some of the pitfalls, where regulation plays a part in it, and all sorts of stuff like that. So if you are looking to just get the basics around AI, that might be one you want to have a look at. We also did a recent webinar on SRA enforcement, where we were looking at some case studies, and that's available on demand as well. So, and it's a free one. They're all free, these ones. So, if you do want to have a look at those, then, do have a look at them. We also have an updated DSAR and sanctions policy that's just been released. So the DSAR is the Data Subject Access Request guidance. So if you're interested in that, then please have a look at that as well. Obviously, these are for people who are subscribing to the various policy and process libraries that we offer. So moving on to the main event, the SRA busy as usual. They've uncovered a significant amount of poor practice in the way law firms are managing high volume consumer claims. And I emphasize they're significant. So I wonder how many firms we're going to be seeing either settling with the SRA on a regulatory settlement agreement, or where it's more serious and the SRA wants to pursue them through to the Solicitor's Disciplinary Tribunal. The SRA has said that concerns include litigation funding, referral arrangements, and poor client care and costs information for clients. And as a result, the regulator is taking the exceptional step of requiring all law firms active in this area to complete a mandatory declaration confirming they are compliant with the relevant rules and obligations. Now, that is an interesting one because they seem to be doing this on pretty much everything now, where they are in effect getting you to say what your position on this is. Now, most firms, I suspect, are going to turn around and tell the truth. But I suspect there will be the odd firm out there, and we saw that with the money laundering declarations and things like that, where some firms have said, yes, we have all of this in place, but when they were actually tested, they didn't. And we saw one recent case where the SRA found, or the SDT said that there was dishonesty, and dishonesty was admitted. So be careful what you actually tell the SRA, because what you don't want to have is a charge of dishonesty coming onto the charge sheet, as well as perhaps, you didn't do things around referrals, you didn't do things around client care letters and things like that. So don't make things worse. That really is the worst thing you can do. If you need to put your hands up, and just take what comes from that. Don't make it worse by then having the charge of dishonesty there. So be careful on that one if you're in the consumer claims area. Money laundering risk. So I don't know whether any of you are working as consultants for the fee share law firms, but certainly this has been raised by the SRA, and they have found that the decentralized nature of consultant-led law firms carries extra money laundering risks that mean compliance officers may need to be more interventionist. And certainly I've done some blogs recently on these types of firms, and the feedback I'm getting from people who used to work in these firms is that yes, the SRA, the concerns they have, they are real. So we need to be careful there. And if you're looking to go into these types of firms, again, I'm just going to sort of reiterate what people have told me, and that is don't believe all the hype that you get in wanting to join these particular firms. And I'm not saying this, all I'm saying is this is what's been told to me. Whether it's true or not, you will need to make up your own minds. But at the end of the day, there seems to be some hype out there to get people in, and then it's totally different. I don't think that's any different from any other firm. They want to sell their firm to get you on board. Whether in reality, once you get on board, things are as it was sold, it's a different matter. So just be aware of that. But just to give you a little bit of detail on that, the SRA said firms of consultants operating semi-independently and often remotely had increased in number since the pandemic. Well, I think we know that. We've seen the headlines. These firm structures can be a benefit to firms and solicitors, but their decentralized nature can carry risks. We have noted that it is sometimes difficult for these firms to keep a central AML, anti-money laundering policy in operation, to monitor compliance and to ensure a consistent standard across the firm. I would agree with that. There are issues in terms of supervising people from a distance and having in the past audited files of firms that have been involved in this. Then it's clear that there are issues around the supervision and things being done as they should be. Firms' money laundering compliance and reporting officers will need to be more vigilant and potentially more interventionist in order to make sure that the firm is not put at risk by non-compliance. And again, some of the feedback, and as I say, it is feedback, it's not my view. Some of the feedback suggests that consultants basically are being left to hold the baby, so to speak. And so the firm, the centralized firm, is putting the liabilities on the consultants. So be aware of that one. And it goes on, firms should also check the level of AML knowledge of new entrants to the firm and undertake training where needed. A new consultant who previously occupied a partnership role may, for example, be unfamiliar with AML processes because these were delegated to other staff. AML training is really, really important. It doesn't matter what firm you're working in, but clearly there are issues here. So, for example, you may well have a firm that is undertaking initial AML due diligence and things like that, and then they pass it over to the consultant who may be 100, 200 miles away. And so you need to make sure that they know what the findings were in the initial assessment, so that they can then look at it on an ongoing monitoring basis. So, be careful. Things are not always as straightforward as perhaps they seem. So, as I say, if you are looking to move into this sort of environment, then you do need to look at all the pros and cons. Axiom Inc.'s update. So this hit the news a couple of days ago. So this is new evidence has emerged showing the SRA failed to check the firm's statutory accounts during its investigation, and it also failed to spot that audited accounts had not been filed. The SRA were already investigating Axiom Inc. in early 2023. That investigation included a forensic investigation of the firm's accounts, but it seems there was no check on the firm's statutory accounts. The SRA therefore didn't identify that the firm had failed to file audited accounts, a red flag that would have justified immediate action. Instead, Axiom Inc. was permitted to remain in business until October 23. So you can quite clearly see there was a gap of 6 to 8 months there that things were allowed to continue. Now, of course, this just adds more woe to the SRA. And one of the blogs that I did this week when this broke was, are we now going to see heads rolling? I suspect we won't, because all the senior people have either left or are leaving in the next couple of months. The CEO still hasn't left. He is due to leave in a couple of months' time. So should he be the first head on the block? I suspect he won't be, but certainly people are calling for his head, because it just seems to be one thing after another that's coming to light on this. Now, of course, SSB, the SSB report is due to come out. I keep on saying it's due to come out. I think we've been waiting for it for about 12, 18 months now. And, we do wonder, some of the skeptics amongst us do wonder whether, in fact, the SSB report will be held back until the chief executive of the SRA actually leaves. Because obviously, if the SSB report comes out in the same shape as the Axiom Inc. report, then it really is going to be fireworks. And as I say, some of them skeptics, including myself, yeah, I mean, we might be wrong, but when we look at the history of things, then who knows? Tony has just come on to say the SRA head of forensic investigations have also just left. Yeah, I know, Tony. They're all fleeing the ship, aren't they? So yeah, it's an interesting one, and I keep on pushing the Legal Services Board for the release of the SSB report, but to date, nothing. So we'll leave it at that for now. Reflecting on competence, so this is the SRA, they're consulting on strengthening the continuing competence requirements. It is not clear whether solicitors are reflecting properly on their practices. So they go on to say the consultation will have a particular focus on reflection and maintaining professional ethics obligations. Well, of course, the professional ethics side of things has come mainly out of the post office scandal. And I suspect in the next 6 to 8 months, we will see the report that gives us all the details around the lawyers. But having watched all of the public inquiry, there are legitimate concerns around the competence and ethical conduct of a number of the solicitors and the law firms involved. So again, there's going to be a lot of fireworks flying around here. The regulator said it was unclear from most of the evidence it had obtained through thematic reviews and reviewing training records whether solicitors were undertaking meaningful reflection on all aspects of their practice. There was evidence to suggest that some solicitors regularly reflected on their practices, identifying training needs with reference to the regulator's competence statement, while others were regularly reflecting on their professional and ethical obligations. That is really good news, but clearly there are people out there who are not doing the right thing. Now, just to add a little bit of flavour to this, the SRA said it had identified 16 solicitors from the 2024 practicing certificate renewals who did not confirm that they had met the requirements of the declaration. And I've had a number of conversations with the SRA about the declaration. Is anybody in their right mind going to turn around and say to the regulator, no, I'm not competent? I didn't really get much of an answer from them. But as a result, it imposed conditions to restrict the practice of 10 of them. Now, it doesn't go on to say what those restrictions were, but of course, when you look at the enforcement strategy and things like that, if you're a conveyancer, for example, they could turn around and say, well, you're not competent to do this, you need to undertake training within X period of time, and then you can go back to practicing. So I'm not quite sure what the full detail is around those conditions that were imposed. It said over the last 12 months, the regulator also assessed 78 reports of competence concerns that did not meet the threshold for enforcement, but the firms involved were required to either make a declaration that they had taken steps. Here we have our declaration again. So if you're saying you're competent and then they find you're not, is dishonesty then going to be put on the charge sheet? So you can see they're putting this across the full gambit of various areas. So yes, it goes on that they have taken steps to address the issue, or that the firm's managers and employees involved in delivering the work had the required professional knowledge and skills to carry out their roles. Now, just to make this a little bit of the moment, we are waiting with bated breath to see which law firm advised the Deputy Prime Minister on their conveyancing and also their tax. And so that's going to be an interesting one. Apparently, the big law firm that was sort of being aired yesterday as the law firm who was advising on this has come out and distanced themselves. They basically said, no, we advised her on this many, many years, but we did not get involved in, what is being looked at now. So people are now saying, well, hang on a minute, if it wasn't them, then who was it? So as I say, we're waiting with bated breath. What will be interesting to see in that particular instance is, was the advice given correct? And if it wasn't, then were there issues around competency for the conveyancing solicitor? Now, one hopes that the conveyancing solicitor would have said, we're not tax experts. You need to go and talk to a tax expert in terms of the trusts and everything else that have been involved in this. But if they didn't, and they decided to basically just go ahead and do things, then they're going to be in trouble. It may be that actually the firm wasn't given the relevant information in order to make proper decisions. There's going to be all sorts of issues coming out from this one, but certainly competence links in there. I think if I was the firm and I was sure of my, what I'd done, I'd be wanting to come out. So I'd be wanting to go to the client and saying, look, we need to defend ourselves here. Can we get you to waive privilege and, allow us to sort of go out there? Now, people are going to make up their own minds if privilege is refused or the waiving of privilege is refused. So it's going to be interesting, this one. Okay. Recent SRA intervention, just wanted to make you aware of this one, just in case you were doing any work with these particular organizations. They have been intervened into and closed down due to suspected dishonesty on the part of a manager. So just be aware of that one. MySRA access, so they've improved security on this one. Now, of course, you're going to need to be going into your MySRA access to sort out your practice certificates and things like this. So you need to be having a look at this because they are using new ways, authentication apps and things like that. So, make sure that you've looked at this in good time because, you will need to get on here for your PCRE access. Changes to the money laundering regulations. Doesn't seem 5 seconds since we had changes, but there are some more in the offing. But these are only draft at the moment. They're basically being put to government. I suspect they will be approved. I have had a look at them. I can't see any fundamental changes. It's very sort of spelling errors and sort of just very minor changes. But what you will need to do is, when it does come out, is make sure that your firm-wide risk assessments are updated, your P's and P's is appropriate, or just that normal thing. None of this applies, but we have read it, just so that the SRA can be kept happy on that basis. But I think on the basis this is likely to come out in the not too distant future, it'll be good if you've got the time, and you need to make the time to have a look at it and be prepared. Okay, we discussed this, I think, last month or the month before in terms of complaints at the complaints procedures being given out at both the start and at the end of matters. And of course, as you would expect, the Legal Services Consumer Panel has backed that. And so, I think there is support for this move to go forward. So just be aware of that. I'll keep you up to speed in terms of whether it becomes a requirement, but yeah, it's just out there at the moment. Nominal complaint fee. So this is the legal ombudsman. Obviously, they have always said that they do not want to charge complainants a fee, but the people at the Birmingham Law Society, so that's their risk and compliance group, they have basically said there should be a nominal fee. Well, I totally agree with that. If somebody has a legitimate complaint and they're going to get their money back if it isn't found to be legitimate, then, you know, what is the problem? But to just allow anybody to put in a complaint, if it's just to sort of try and get a bit of fees off or whatever it might be, yeah, I think there should be some form of consequence. You know, clients need to think up front, do I really think I have a complaint, or am I just sort of playing the game, as they say? But the Birmingham Law Society says this would filter out those complainants whose complaints are entirely without merit, but who consider it worthwhile to complain in the hope that the law firm will make a nuisance payment to rid themselves of the problem. And of course, we've got the legal ombudsman looking to increase the case fee from £400 to 600. It was 800, but I think they're going to be settling on 600 at some point. Then these sorts of clients who are playing this game will know that you potentially are on the hook for £600, and therefore by making a complaint, you might want to settle at 400, something like that. So I think it is right time to be putting this sort of thing in place. Whether, you know, the legal ombudsman will do it, whether the legal service consumer panel will object and the government will object, who knows? But it's out there. Law Society SGM. So this one came in, I think, yesterday. So the Law Society planning a 10-fold rise in the threshold for mandating an SGM. Now, of course, the last SGM we had was the one around the TA6 form, I think it was, and the vote of no confidence in various individuals. Currently, only 100 society members are needed to trigger an SGM for a specific purpose, equal to 0.05% of the 216,000 strong membership. The society CEO maintains that the threshold of around 1,000 members would be easily achieved in today's social media landscape, where support can be rallied almost instantly. I have seen a number of blogs and posts that have come out since this, and there are a lot of solicitors who are against it because they believe that this is silence or trying to silence critics. So it's going to be interesting to see where this one goes. But if you are a solicitor, then obviously you need to have your input into this one. Client account interest. So legal aid firms will be the first to suffer if the MOJ presses ahead with this. We have discussed this one. What they've said is the interest on lawyers' client account scheme would require law firms to forego the interest they currently receive on their client accounts. This is according to the invite to these online roundtables that have taken place this month. According to a council member of the Institute of Legal Finance and Management who attended the event, the MOJ couldn't say how the scheme would work or what the money would be used for, although they did confirm that they are talking about interest for all law firms. Well, I mean, that's an interesting one because when you look at government, you know, they are talking about getting in money and then spending it on a particular cause. And then when they need the money elsewhere, they then say, well, actually, we're going to move it over here. So will it actually go to legal aid in the end anyway, if they do decide to put this in? So it'll be an interesting one, but it will also be interesting because actually a lot of firms tend to use that interest to offset banking costs and other things like that. So is this going to achieve what the government or the Ministry of Justice want it to? I'm not quite sure. And I think a lot of firms will have their thoughts on that one. But I think one of the important things, and I've mentioned this in the past, is that firms who are heavily reliant on client interest need to be really, really careful because if they are that reliant on it, that if it was taken away, it would cause financial difficulties, then the question is, have you reported that as a consequence or a particular issue to the SRA that could cause your financial instability? And you have an obligation under the Code of Conduct to report things that might impact your financial sustainability. So just bear that in mind. Residual balances. So this is something that came in this morning. A leading firm of accountants says 2/3 of law firms whose books it examined for regulatory reports had broken the rules on residual balances. I did a LinkedIn post on this morning. And so what I basically said was that, well, if that is the case and we extrapolate that across the profession, then 2/3 of fee earners have not been doing their job right. Because residual balances only are there because fee earners have just thrown the file in the corner, having sent out the bill and saying, you know, we'll get around to doing clearing the balances and closing the file later. And of course, later never comes. Well, that is poor conduct as far as I'm concerned, because they should be dealing with it all. A fee has not been earned until the file has been properly closed. And that means clearing all the balances. And what I have suggested previously and in the blog that I did this morning is that residual balances should be a discussion point for appraisals, one-to-ones, where you are looking to do bonus payments if you're doing them, or salary reviews. And so if you have all these residual balances, there is poor performance. Well, are you going to actually pick up poor performance then? You shouldn't really be waiting for annual appraisals. If that's what you do, you should be picking them up immediately. Or when we have residual balance reports being put to the partners and the partners are just turning around and saying, oh, well, just let accounts deal with it. No, you've got a conduct issue here with a number of fee earners. You need to deal with those. So, you need to look at this. And if fee earners are not willing to go with the flow, then you need to hit their pockets. And if you turn around and say, well, your bonus is going to be impacted, salary reviews are going to be impacted, people will soon realize that actually they need to change their ways. Leave that one with you. Perception of support staff. And the reason I put this one straight after the previous one is because I get told on quite a lot of, I have been told on a number of times that when the account staff go to fee earners with the residual balance list to say, can you clear this, please? They are either told to go away or have the door slammed in their face or other things. And I think this just goes to show that, there are issues out there. So it is a uniquely arrogant and complacent facet of law firms that partners think some business functions are dispensable support functions rather than core elements. And this is a senior lawyer who is saying this. He goes on to say that infighting among partners driven by the blinkered pursuit of profits per equity partner could result in the law firm model moving to something resembling the Hunger Games. So he doesn't hold back on that one. Account staff are doing what they're supposed to be doing. At the end of the day, if the fee earners were doing the job right in the first place, they wouldn't be needing to go to them to say, can you clear your residual balances, please? So again, the fee earners involved haven't got any excuse for this. And treating anybody for whatever reason in an arrogant and harassing way or whatever is totally unacceptable. So it's just not acceptable. But clearly, there are concerns that this is happening out there. And it's not just this person. Obviously, this is the partner that I've sort of picked up on here. But I saw something the other day where, junior solicitors were basically saying that they're being picked on and things like that. So clearly there are issues out there. Cyber resilience. So this is the government tightening its stance on cybersecurity through the Cybersecurity and Resilience Bill. So that's something that you need to keep an eye on. The bill seeks to improve the UK's national cyber resilience and incident readiness, to strengthen the cybersecurity standards expected of essential and digital service providers, and align UK regulation more closely with international best practice, including elements from the EU's NIS2 directive and the US Cyber Incident Reporting for Critical Infrastructure Act. So lots of things going on in the cyber field, so keep an eye on that one. Make sure that your systems are where they need to be. Cyber Essentials, this was an interesting one. Just 19% of barristers' chambers currently meeting the standards of Cyber Essentials. This was IT services provider Atlas Cloud saying a check of the official register of Cyber Essentials certifications showed that just 74 of the 321 multi-member chambers had certified within the last 12 months. Now, the question that came to my mind is, can law firms then trust chambers who don't have Cyber Essentials to look after client data? Well, maybe that's a too broad a question to ask, because they could be asking the same sort of question of you, do you have Cyber Essentials? But I think at the end of the day, what you do need to do is make sure that anybody you are liaising with and sort of passing client data to have the appropriate cyber protections in place. Whether that is having Cyber Essentials or just giving an assurance that what they are doing in terms of cybersecurity is where it needs to be. Because at the end of the day, you are data controllers, and therefore you have a duty to make sure anybody you're passing data to on your behalf are doing the right thing. AI usage, mentioned earlier on the LinkedIn Live session that I did the other day. So this is 6 out of 10 lawyers using generative AI for work purposes. Most of the rest plan to. So this is new research. Also said that small firms were twice as likely as large or medium-sized firms to rely heavily on AI for day-to-day work. Now, of course, and I was talking to a colleague about this earlier on, it really depends on, well, what is considered to be AI. Some people would say case managements are AI. Some HR systems might be, AI. So it really depends on, what you're talking about in terms of that. So the majority of lawyers, 56%, said they spent time saved by using AI on increasing billable work, while almost as many, 53%, said they used it to enjoy a better work-life balance. So this is LexisNexis gathering responses from over 700 legal professionals in the UK for the report. Brings you to a number of different issues. That one, the better ones are obviously the work-life balance and the billable time. But of course, in terms of, if you're able to increase billable time because you've saved all this time, are you actually then passing the savings that you're making through using AI onto clients? Well, that's going to be a discussion in itself. And I'm sure the SRA are, looking at that one as we speak, because the question is certainly out there, and the SRA has said it's looking at it. So, this is not just, oh, well, we'll use AI and we'll still charge clients the same amount of money. You've got to act in the best interest of clients. You've got to maintain the public's trust in the profession, and perhaps, as some people would see as overcharging, that is something that you need to consider. Understanding AI. So this is a specialist arguing that lawyers have a new duty to have a competent functional understanding of artificial intelligence. And I talked about the LinkedIn Live event I did. If you just want to get an understanding as to what it's all about, then have a look at that. But a competent functional understanding, it follows the same sort of logic that we have with money laundering software. So the online checking systems that look at CDD and things like that. You've got to have, according to the SRA, you've got to have, in effect, a competent functional understanding of the system that you are using, what it does, what it doesn't do, what it produces, and what it produces means. So again, we seem to be seeing a trend here with the use of technology. So make sure that you do understand that. So this is a solicitor who runs a legal consultancy, said lawyers could no longer just rely on IT departments and third parties to manage their tech. he says today's lawyers must engage with how these systems operate. Where does the data go? How secure is it? How does it interface with other systems? And that basically leads on to data protection, because when you are looking to move into AI or wider use of AI, you should be doing a data protection impact assessment to have a look at, well, how does this new way of working that we've adopted, how does that actually deal with personal data? What are the risks to personal data? So I just mentioned there in terms of, where does the data go? How secure is it? That is all stuff that should be picked up in a data protection impact assessment. And if you're wondering what one of those is, well, you can go to the Information Commissioner's Office website and have a look at that. And I think they actually provide a template for that. So, use what is out there. But he goes on to say, AI is no longer just another program. If it produces a result you act upon, you must be confident in its integrity and reliability. How true that is. And I picked up the other day a register of all the hallucination cases around the world, not just the UK, but around the world, where lawyers, people who are acting for themselves, have basically gone straight into ChatGPT or other systems and said, give me case precedents around this. And they've been wrong, or they just haven't existed. So making sure that the product from the AI is as it should be. Funnily enough, one of the cases being quoted in a particular case was supposed to have been produced by the judge in that particular case. And he said, hang on a minute, I didn't do that. That's nothing to do with me. And that's how he basically found out that, the precedent was wrong. So, you will get caught out if you don't check it. And as I say, it's not AI that's the problem. It's the people who take what it produces on face value and without question who are the problem. So you need to understand what it's all about. Fraud prevention. So this is large firms that overbill their clients. So this is the very large firms in effect, but I don't think there's any reason why smaller firms shouldn't be aware of this one, because you shouldn't be overbilling your clients. But if they overbill clients, make false environmental and diversity claims, then they can be prosecuted under the new legislation. So this is the failure to prevent offences under the Economic Crime and Corporate Transparency Act. Large organisations are those which meet 2 out of the 3 criteria. And as I say, I suspect the vast majority of you won't meet this. More than 250 employees, turnover exceeding 36 million, and a balance sheet total exceeding 18 million pounds. And they've given an example here. If a fee earner deliberately inflates or rounds up time entries, this conduct could trigger liability for the firm, even if the matter partner is entirely unaware of it. As well as overbilling, misrepresenting a firm's green credentials or diversity record to win clients could be regarded as fraud. It could also include fraud by silence, for example, deliberately not notifying a client about a data breach in order to stay instructed. Well, that broadens things quite a bit. But I think even if you're not caught by this particular act, you would be caught if you had these particular issues by acting professionally under the Code of Conduct and the SRA principles. So it does apply to everybody. It's just that the bigger firms are obviously held to a higher threshold. First TPMA for the CLC, which is interesting because, of course, it's been the conveyancers who have, in effect, been the loudest when saying, well, we don't want this because it doesn't work. So it's going to be interesting to watch this one. But what I did notice was that the Digital Property Exchange, which owns the law firm that's done this, will be its TPMA provider. Also plans to provide a TPMA for another firm regulated by the SRA. So we're getting in here with both the CLC and the SRA. But as I say, people have commented on this, in effect saying, well, of course they will be wanting to do this because the TPMA provider owns the firm, and so they will want them to use it. So make of that what you will. Whether that will have an impact on the SRA's views of TPMAs, other people's views on TPMAs, whether it will work. I mean, if it doesn't work, will we ever hear about it? I'm not quite sure because of the vested interests, but there you go. But you can see things are changing, even though it's not in the SRA regulated sector. The importance of supervision. So I wanted to put that one out there. So this is a managing partner failed to convince the SDT to blame the 1-year qualified solicitor he was supervising for multiple failures on a conveyancing transaction at an undervalue. The SDT said the partner, who also held both of the compliance roles, had expressed concerns about his clients being coerced at the outset of the transaction, but then did nothing to satisfy himself that this was not the case. Given his role and experience, he was more culpable than the newly qualified solicitor. So we've got somebody who was supervising, but actually were they qualified in themselves to supervise, even if they were the culp and the coffer? I mean, obviously it talks about compliance roles. They may have been the MLRO, the MLCO, and everything else. Who knows? But quite clearly, supervision is really important of the individuals who are being supervised, but also for the people who are doing the supervising. So they need to be doing the right thing as well, and certainly not satisfying themselves in relation to something that was a red flag. It's not a good move. Building safety regulations. So this is for the conveyancers amongst you. So this is Silex who's raising this one. So this is Silex wanting to remove, or insurers to remove, the block on conveyancing and advising on this. But I think until we get a lot of clarity, a lot more than we've got at the moment around this, I think a lot of people will be taking the easy route and saying, well, we're just not going to advise on it. Does that serve the best purposes of people? Maybe not in terms of clients, but if a firm sort of protects its back from future litigation or whatever, well, one can understand why they will want to do that. I mentioned practicing certificates earlier on. Well, that's going to run from the 1st to the 31st of October, so start getting your data ready. Haven't seen the fields that have got to be filled in yet, but go into your MySRA. Don't forget you've got to sort of look at the new app to get in there, so set that up as well. Make sure that people, that when it comes, if you are the culp and you're filling in where it says, yes, everybody is competent, that in fact they are competent. Because again, you're giving an assurance to the SRA by ticking that box that everything is fine. Now, bearing in mind, they are looking at competency and reflection statements, then it may be they're going to start calling in records and things like that. So the fact that you've given an assurance, if it's the wrong assurance, they may well pick that up in due course. And it goes back to the point I made earlier on. You don't want to have a dishonesty charge put out there for misleading the regulator. So time is of the essence. So you've got a month now before it all kicks off. You've then got a month to put it in there. So time, hopefully you will have time to look at that and make sure that everybody is doing the right thing. Notable disciplinary cases to finish on. Been quite a few. Just picked out a couple there. So we had a senior, so we talked about billing a moment ago, senior associate who recorded 23 hours of chargeable time in one day, been struck off for submitting dishonest timesheets. How do these people think they are going to get away with this when, partners will be reviewing records and things like that? It just amazes me. But, clearly people either working too longer hours, or definitely doing the wrong thing, and they're obviously found to be doing the wrong thing here. We've then got on the other side of the slide 2 solicitors who took confidential client information from their former employers, been rebuked by the SRA, again, comes back to data protection, comes back to principles of integrity, honesty, the perception clients have of the profession, best interests of the clients, confidentiality breaches, all sorts of different things. So just make sure that when somebody is leaving your firm, you make it clear to them that they are not taking client data with them unless they have your consent and they have the client's consent. And if you are the receiving firm of an individual, you need to be asking, have you brought any information from your previous firm that has not been approved? And if they turn around and say no, and it later turns out that they have, then of course you've got them there. If they turn around and say yes, well, again, you need to then be taking action on that, because if you don't, then you're the one that's going to come into the firing line when everything starts to hit the fan, as they say. So do make sure that both your exit processes and your induction processes pick this one up, because you certainly don't want to get caught out on this one. So that brings us to the end of this month. It was a fairly quiet month this month, with it being August and obviously people on holiday and things, so I'm sure things will start to ramp up. We've got the SRA's compliance conference coming up fairly soon. For those of you who are going to go, I have asked the SRA if they are going to allow us the open mic session like they did apart from last year, and they have come back and said, nope, you're not getting it. One, because there's too many people, two, because of the location, and so I went back to them and said, well, hang on a minute, last year we had the same place, we had the same number of people, you had the open mic, so what's the difference? And I think the big difference was Axiom came onto the radar last year, and they didn't want difficult questions asking of the chair and CEO. But they haven't responded to my further blog on that one. So I suspect they just want that one to sort of go away. But yeah, there's lots flying around there, and it'll be interesting to see what comes out. Be interesting to see whether the new chief executive is actually there as well, or whether last year was the sort of the final goodbye from Paul Phillip, the existing CEO, and we'll have the new one there this time round. So we'll see. Anyway, moving on to questions. Babel, apologies if you weren't able to download the missing slides, but they are, not the missing slides, but the slides. They are downloadable on the system, but you will be getting them anyway. So that's fine. Yeah, Hankies, thank you very much for just confirming that they were on the dashboard. Yeah, so slides available. And Tony, as I say, we covered that earlier on, but for anybody who missed it, when I was talking about sort of the mass evacuation at the top of the SRA, Tony was then saying that the SRA head of forensic investigation has also just left. So I think we've seen probably 5 or 6 of the senior honchos either having left or are leaving in the next few months. And we also have the chair, of course, leaving in the next 12 to 18 months. So all sorts of things going on there. If you have any further questions, please do put them on the system. I'll hang around for a little while, but I can't see anything else coming in. Of course, if you don't want to ask the question now, then please feel free to contact me via email. The email is on the front slide of the presentation, and I'll do my best to answer the question. If I can't answer it, I'll find out who can. But I'll then come back to you with the answer on that. No, we don't seem to be having anything further coming in. So I think I will draw a line under proceedings there. Let you get back to your day job. Thanks very much indeed for attending. And as always, stay safe. Bye-bye.